Hey folks, Christina here. This video is going to cover chapter 9 from our OpenStax textbook, and we're going to talk about employment and labor law. This chapter is a hefty chapter that covers lots of information. So get your notebook ready so that you can take some notes and set yourself up for success. Okay, the first thing our text talked about was employment and at-will employment. Now, here's a neat thing. Up until 1959, employers had the right to fire a worker without any reason. This is technically what's called at-will employment. But the cool thing is, at-will employment continues today unless you're a collective bargaining agreement, unless you're working under one of those. And another thing that we'll learn about is at-will does not cover illegal reasons for termination. So we're going to talk a lot about that as we move forward today. I've got a link here in the slides for my students if you want to look a little bit deeper, a little bit closer at the at-will employment in the state of Oregon. In our course shell, you can open up these slides, click that link, and it will take you, excuse me, it will take you to the state of Oregon's employment at-will site. Okay, let's talk a little bit about, oh, I skipped quite a few slides here. Okay, let's talk about health and safety for workers. You probably have heard the term OSHA before. That is the Occupational Safety and Health Administration. It's a federal agency that has the responsibility of assuring safe and healthy working conditions for workers. They were put in place, OSHA was put in place by the Occupational Safety and Health Act that governs safety in the workplace. Now, OSHA's mission currently on their website is to assure America's workers have safe and healthful working conditions free from unlawful retaliation. And we've talked a lot in our class about retaliation, and OSHA is one place that addresses that for us. In your textbook, there's some different information on page 88 about OSHA that you might want to check out. Next up, we're going to talk about the workers' compensation. And the Workers' Compensation Act helps employees claim compensation for injuries that happen on the job. There is something called the Workers' Compensation Agency. They're established at the state level to provide judicial and administrative services to help in the resolution of claims for compensation. And here are the steps, as our text says. The worker first files a claim with the agency. The agency establishes the legitimacy of the claim. And if the injury is determined to be legitimate, compensation benefits are paid accordingly. Now, one thing that's very important to understand about workers' compensation is this thing called exclusive remedy. This term means that a worker can't sue the employer in court for further damages beyond that which is paid out under their individual workers' compensation claim. So they can't get a workers' comp claim and then turn around and sue their employer again for additional damages. An exception to this is when the employer intentionally injures the worker, and workers also have the right to sue any third party involved in the cause of the injury to recover additional damages. That might be vendors, it might be suppliers, etc. Next, we have our Fair Labor Standards Act, also called FLSA. This sets out provisions that delineate fair labor from unfair labor. And there are three categories that fall underneath this Fair Labor Standards Act. The first is child labor, then there is minimum wage provisions, and then there's overtime pay requirements. So let's take just a little bit of time to chat about those. So the FLSA, or Fair Labor Standards Act, prohibits oppressive child labor as well as the shipping of goods produced by firms that make the use of oppressive labor. The Fair Labor Standard Act sets the minimum age for non-agricultural work. At the time of our text, it's 14. If you're watching this sometime in the future, it might be different. There are also some exceptions. People who are under the age of 14 who are classified as minors may deliver newspapers, they can do babysitting or chores around the home. They can also work in businesses owned by their family as long as the work is not deemed to be hazardous. Under the terms of the FLSA, Employees in covered industries, with the exception of apprentices and students, must be paid the federal minimum wage for their work. So Congress is responsible for reviewing the level of the minimum wage on a periodic basis and raising it to compensate for increases in the cost of living caused by inflation. The FLSA also mandates that employees who work more than 40 hours in a week should receive overtime pay that is equal to at least 1.5 times their regular wage for every additional hour worked. 4 categories of employees are excluded in this overtime pay. So these are executives, administrative employees, professional employees, and outside salespeople. Next, we're going to talk about the Family Medical Leave Act, also known as FMLA. So this act puts in place a guarantee for eligible workers to have up to 12 weeks of unpaid leave in any 12-month period for family and medical emergencies. Some of the things that are covered under FMLA are the birth of a child, adoption of a child, placement of a foster child in the employee's care. So if you are going to be having a foster child placed in your care, you could approach your employer about FMLA leave. The third is care of a seriously ill spouse, parent, or child. And finally, any serious health condition that prevents the worker from being able to perform any of the essential functions of their job. Now, as part of that FMLA, once that time frame ends, the employee returns to work. Typically, they will be released with a physician's release. So a doctor will say, you can go back to work with or without exceptions, and they'll define that out. And under FMLA, the employee must be restored to the same or equivalent position. And it's really important to note that it is the same or equivalent. You might not have your same job when you come back from FMLA, but it has to be an equivalent position. So that's an important piece to know about this. Next, our text talked about some of the regulations for ending employment. And this table is table 9.2, page 90. So you can take a look at that and review that for your information. Next up is immigration law in this chapter. And I have in our slides a couple of links. So here you'll be able to click on the U.S. Citizenship and Immigration Services website. They administer programs that enable U.S. employers to employ foreign national workers. The second link that I have here is the Immigration Reform and Control Act of 1986. This required employers to examine evidence of employees' identity and to complete mandatory paperwork for each employee. So our text, the OpenStax text at the current time, does not have a lot of information about immigration law. So I wanted to add these two links so that you could have a bit of additional information if you would like to look at that. Next up, we have section 9.2, which is all about labor law and labor relations. So let's look at some terminology. Labor relations is just a general term that is used to talk about or describe the relationship between employers and employees, as well as the governance of that relationship. So how does that relationship work? Trade unions or labor unions, you probably have heard them called labor unions in our area. Those are organized groups of workers who come together to lobby the employers about conditions affecting or impacting their work. And then you'll see in our text, there's a term called yellow dog contract. This is a contract that prevents a worker from joining a labor union. And we'll learn a bit more about that in just a minute. Now, we've got a timeline of the developments in labor law here in America. In 1886, the American Federation of Labor was formed. They were actually formed in Ohio. So this was a national group of labor unions that came together to kind of boost or bolster their power in industrial unionism. The AFL, as they're called, they were the largest union group in the United States well into the 20th century, with the exception, they had their membership was craft dominated. And what that meant was they were the largest, but only craft workers like artisans and silversmiths were allowed to belong to the AFL. In 1932, the Norris-LaGuardia Act was passed, and this act prohibited yellow dog contracts or contracts that prevented workers from joining labor unions. In addition, the federal courts are barred from issuing injunctions to prevent groups of workers from engaging in boycotts, strikes, and picketing. Also, in 1935, the Congress of Industrial Organizations was established. So this establishment extended our union movement in America. It allowed what is called semi-skilled and unskilled workers to become members of labor unions. So before 1935, you had to be an artisan or a skilled craftsman. And the Congress of Industrial Organizations expanded the ability for folks to join unions. Also in 1935, the Wagner Act, more commonly known as the National Labor Relations Act, was passed. This was a major statute in U.S. labor law. This act established that employees have the right to form, assist, and join labor unions or organizations. They also can engage in collective bargaining with their employers, and they can engage in activity to promote their rights. So this was a big act when it came to labor law in America. In 1947, the Labor Management Relations Act, also known as the Taft-Hartley Act, and I've got a whole separate slide about this one, they imposed restrictions on the power of labor unions. It made changes to the union election rules and outlined provided remedies for 6 unfair practices by labor unions, and those are listed here in the slide. Back to our timeline, in 1959, the Labor Management Reporting and Disclosure Act, or the Landrum-Griffin Act, was passed, and this regulated the internal affairs of all trade unions, as well as their officials' relationship with employees. All the union members are granted equal rights to vote for candidates, take part in membership meetings, and nominate candidates for office of their local labor or trade union. Then, in 1988, the Work Adjustment and Retraining Notification, also known as WARN, that act required that employees with more than 100 employees give workers at least 60 days notice before engaging in layoffs or plant closings. Now, back to this Taft-Hartley Act of 1947. Like I said, this one completely reshaped our U.S. labor relations by balancing union rights, employer power, and worker freedom through key reforms. I've got a link here to an overview from UpCouncil if you want to dig a little bit deeper on the Taft-Hartley Act. Okay, next we're going to talk about the National Labor Relations Board, or the NLRB. This board was established to administer, interpret, and enforce the terms of the National Labor Relations Act. It has jurisdiction over all workers with a few exceptions. Those exceptions are government employees and employees in the transportation industry. They're governed under separate acts, so they're not under the NLRB. Others that are not covered under this are agriculture workers, confidential employees, independent contractors, and those who are employed by a spouse or a parent. Now we're going to talk about, okay, what if you want to organize a union? There's some specific steps that have to take place in order to organize a union. First, you have to identify an appropriate bargaining unit. And when we say bargaining unit, what we mean is a group of workers that the union will represent. You also begin soliciting employees, and in your text, it talks about this inaccessibility exception. And what that means is employees and union officials have the right to engage in union solicitation on the firm's property if they cannot otherwise access employees to communicate with them. After you've solicited your employees, then you'll run an election. And there are a few different kinds of election. There is a consent election, which is held when there are not any substantial issues under dispute between the union and the employer. Both parties agree to waive what's called a pre-election hearing. There's also a contest election. This election is when a union is contested by the employer. The NLRB, National Labor Relations Board, is required to supervise this kind of election, and you could probably imagine why. Then there's a decertification election. This is held when employees indicate that they wish to vote out the union or join another union. Now, in order to bolster the power, elected unions often attempt to secure what's called a union security agreement. This agreement just pertains to the extent to which the union can demand that employees join the union and whether the employer will be required to collect fees or dues on behalf of the union. So you can see administratively why that would make sense. If you have the employer collect those fees, they can disperse them to the union, etc. And there's a few different types of shops that are included under this union security agreement, and we'll look at those definitions. So first is called a closed shop union. This is a workplace where the union membership is a requirement for employment. So that's a closed shop. You can't work here if you're not in the union. The next is a union shop. So this is a place of employment where the employee is required to join the union within a specific number of days after being hired. Maybe it's 90 days, maybe it's 60 days. That's called a union shop. Then there's an agency shop. So this is a workplace that doesn't require the employee to join the union, but where agency fees to the union may be paid. And the reason they do this is union security agreements. Typically, the union is going to cover everyone that's in that shop, in an agency shop. So that's why they have it set as that way. Okay, next we're going to move on to collective bargaining. So collective bargaining involves the union or the employees and the employer. And what they're doing is they're negotiating terms of the contract. The outcome or what comes after the negotiation is called a collective bargaining agreement. You typically are going to hear that called a CBA. So that collective bargaining agreement is what employees typically will call their contract. And that is, again, the result of the employees in the union and the employer negotiating. If union members dispute working conditions, unfair labor practices, or the terms and condition of their employment or economic benefits, they have the right to participate in cessation of work activities. This is known as a strike. So let's say we're negotiating our wages and salaries, our working hours, our terms and condition of employment, the working conditions, vacation days off, and we can't come to an agreement on one of those key pieces. Then we can move into what's called a strike, and also we can do picketing. So if union members dispute those working conditions, unfair labor practices, or economic benefits, they do have that right to cease work activities, also known as a strike. There is, in most contracts, a mandatory cooling off period of 60 days before a strike can commence. Some CBA include what's called a no strike contract while the employees are under contract. So they can't strike while there's a current contract in effect. In addition to a strike, members also have the right to picket. This means walking in front of the employer's premises with signs that advertise the strike and the union demands. There are limitations to strikes and pickets by law. Our textbook says some of those. And if you're in a local union, your local union reps will be able to tell you what those limitations are for strikes and or picketing. All right, we're going to move on to section 9.3, which is all about equal employment opportunity. There are several laws that govern equal opportunity in employment. Employees are protected in the workplace by these laws. There are federal and state levels of the laws. And in our book, it talks about federal laws are usually considered to be the minimum level of protection, and then state laws can generally provide employees with more, but never less protection. So let's take a look at one you're probably all familiar with. This is the Civil Rights Act of 1964, which was amended in 1991. Most commonly, this is known as Title VII. So it's title and then the Roman numeral 7. It deals with discrimination in employment or in the workplace. And What it does is it ensures that bars employers from discriminating against employees in hiring, promotion, and firing practices. And it's got some protected classes listed in Title VII: sex, national origin, color, religion, race. And so, what we want to look at is discrimination under this Title VII. So there's a couple of ways in which discrimination can be proven, and they're called disparate treatment or disparate impact. So disparate treatment means that the employee believes that they have been discriminated against on the basis of one of those protected classes set out in the Civil Rights Act. Proving that the employer engaged in disparate treatment is a three-step process. And here's what that is according to our text. The employee is required to demonstrate that there was a case of discrimination. The employer has to show legitimate, non-discriminatory business reasons for undertaking the action. And then third, the employee must demonstrate that the reason given by the employer is a mere pretext. So it's not true. Then, when we want to look at disparate impact, these are what we call cases of unintentional discrimination. This type of case occurs when the employer engages in a practice that has a disproportionately injurious impact on a protected class. So it's a case of unintentional discrimination. The employer engages in a practice that has disproportionately injurious impact on a protected class. It is difficult to prove, as the burden of proof always falls to the employee in this. And in your text, it gives an example that I would encourage you to take a look at. It's a good case. It is Giggs versus Duke Power Company. So definitely take a look at that in your text for a bit more information. Under Title VII, employees have some additional protections. One of those is the protection to be free from sexual harassment. This is under Title VII. This type of harassment is defined as unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature. And there are two types of sexual harassment considered under Title VII. The first is called quid pro quo. This occurs when a manager or supervisor makes a sexual demand on a worker, and this demand is perceived as a condition of employment. This is considered sometimes if you want to work here, you must do this, fill in the blank. So that's what a quid pro quo is. Another way or another measure of sexual harassment under Title VII is a hostile work environment. So actions that create a hostile work environment are under this sexual harassment section of Title VII. Our text also talks about, in some cases, employers can be liable for harassment of employees by non-employees. This could be a customer, it could be a vendor, things of that nature. So as an employer, you want to really be careful and consider all the ways that you're protecting your employees. And another way that Title VII offers protection is through the Pregnancy Discrimination Act. This actually came about in 1987. It expanded the definition of sex discrimination or sexual discrimination to include discrimination based on pregnancy, childbirth, or medical conditions related to that pregnancy or childbirth. And so that's an important one to consider there. Your text also gives some defenses to the Title VII claims. This is on table 9.5. And one of the ones I want to talk about quickly is the merit defense, or two of them, the merit defense and the seniority defense. So the merit defense is used when decisions pertaining to hiring or promotion are made on the basis of the results of test scores. However, tests need to be validated in accordance with professional standards and must be related to job performance. Then there's the seniority defense system. This defense occurs when employees are given preferential treatment because of their length of tenure or their length of time at the job or their seniority. As long as the system does not have its genesis in discrimination and it is not used to discriminate, and it applies to all people equally, it is lawful. Okay, next we're going to talk about the Equal Pay Act. So the Equal Pay Act seeks to equalize the salaries and wages paid to employed women with the levels paid to men for work of an equal nature and quantity. The following must be demonstrated if a case of unfair Equal Pay Act is made. First, an employer has to pay one sex more than another. Second, both sexes have to perform an equal amount of work that demands equal levels of skill, effort, and responsibility. And third, working conditions for both sexes have to be equivalent. All right, there's a few affirmative defenses to the Equal Pay Act as well. Here's an example. An employer may pay employees of one sex more than another sex if the wages are based on a system of seniority, a system of merit, a system that distinguishes payment on the basis of quality and quantity of production. For example, if we're counting piece rates, or if payment is differentiated on any other factor rather than sex. Of these four defenses, the factor other than sex is the one that has been invoked the most frequently, and it has been the subject of intense debate and controversy. Lots of critics have argued that this defense enables employers to fabricate other reasons for the wage gap that exists. Now, in our text for these last few things that we've talked about, your text is at a high level. So there's many resources, many references that you can look at to get additional information. So I want to encourage you to do that. Next, we have the Americans with Disabilities Act. This act is set up to prevent employers from discriminating against workers on the basis of their physical or mental abilities. Employers are required to make reasonable accommodations to known disabilities as long as they do not impose an undue burden on business. Now, with every employer, there is a there's a way that you reach out and ask for your ADA accommodation. Typically, you're going to need some type of notification from a physician, but your employer is required to make reasonable accommodations to known disabilities. Employers can't make accommodations for things they don't know about. So it's important to have that discussion and to make that known. All right, our last act of the chapter is the Age Discrimination Act. This was actually passed in 1967. And this act prohibits employers from making discriminatory employment decisions against people age 40 or older. And so that is the reason for the Age Discrimination Act. Now, as I've done in previous lectures, you've got in our course, you have this slide deck, so you can take a look a little bit deeper at some additional resources here. I've got one on the Equal Employment Opportunity Commission. I have one that is Federal Employment Law Basics for Small Businesses. And then I have two from an Oregon law firm. It's the Meyer Employment Law. They have an article on employment law for your small business. They also have an article on Oregon employment discrimination law. Now, as I say on every video, if you're experiencing one of these situations, it's important for you to consult your own legal counsel. I am not an attorney, but I do teach business law. So if you're having your own legal situation, I would encourage you to reach out and connect with legal counsel. All right, folks, that wraps up chapter 9, and I will see you soon for chapter 10.